Welcome back for the second panel in today's exciting program celebrating Mark's work. My name is David Simson. I am an associate professor here at New York Law School. I teach constitutional law and courses on racial justice, and so it's a special privilege for me to play a very small role in this panel. And I wanted to thank Professor Penny Andrews for including me in the program. I wanted to thank Mark for writing the book, which already has made me think about teaching, my writing, and everything else, which is, I think, what good books do. And thank all of the panelists for what they have to say, which I already know a little bit more about than all of you, and I'm very excited to hear. So our general format, I will just very briefly introduce our speakers, and then we'll go in the order that's listed in the program. We'll start with Professor Chambers, then Professor Levinson, then Professor Vojdik, and then we'll first give the panelists an opportunity to respond to each other, and then we'll go to audience questions. Okay. So first, we'll hear from Professor Henry Hank Chambers Jr., the Oliver Hill Faculty Research Scholar and Professor of Law at the University of Richmond School of Law, who teaches and writes in the areas of constitutional law, criminal law, law and religion, and employment discrimination. Professor Chambers has served as Special Assistant Attorney General for redistricting matters in Virginia, lectures on constitutional law through We the People program, which provides civic education instruction to school teachers and the public, and at James Madison's Montpelier and at the Federal Executive Institute in Charlottesville. Next, we'll hear from Professor Sanford Sandy Levinson, who is the St. John Garwood Centennial Chair in Law at the University of Texas School of Law, where he's also part of the Department of Government as well, who has written too many books for me to tell you and list them all, and articles as well, but is an expert in constitutional law in all of its facets, and has been a visiting faculty member at BU, Georgetown, NYU, Yale, and various other places around the world. And then Professor Valerie Vojdik, the Waller Lansden Distinguished Professor of Law at the University of Tennessee Winston School of Law, is an expert in civil rights litigation and gender and the law, and was the director of the clinical programs there from 2011 to 2015. Currently teaches civil rights, sex, gender, and justice, federal courts, and civil procedure, with a scholarship focus on gender and the law, feminist jurisprudence, masculinities theory, and international legal issues involving gender and sexual. And now I will shut up and we'll turn it over to Professor Chambers.
Thank you so very much. I appreciate being invited here, and thank you, Penny, so much. Thank you for the tea break as well. I have to admit, it does put in my mind. Oh, sorry. I have to admit, it does put in my mind the song from Sting, An Englishman in New York, because it starts with, "I don't drink coffee, I take tea, my dear." So that's just that's going to stay in my ear, and hopefully it'll stay in yours as well as a consequence. So this book is fantastic. It's fantastic, and I'm going to try to be even remotely I'm not sure I can even be critical about it, because I have a lot of fun with it, and because obviously I have a ton of respect for Mark. The book and the project, the bigger project, should receive more attention, even more attention than they have. The book is wonderful, and it's a good read to boot. Now, Mark makes the case in unrelenting detail that the 14th Amendment's point is to reward loyalty and punish treason. In addition, the book makes clear that full racial equality was not the point of the 14th Amendment, and makes the related point, contra many scholars, that Section 1 was not the core of the 14th Amendment. So he argues that Section 2, 3, and 4 are the core provisions of the 14th Amendment. Indeed, Mark initially makes the point by discussing Osric, a truly minor character in Hamlet. And he likens Osric's role in Hamlet to Section 1's role in the 14th Amendment. Now, he softens his dismissal of Section 1 by suggesting, quote, "Section 1, if not Osric, was no more than Polonius, Horatio, Ophelia, or Laertes, and certainly not Hamlet, Gertrude, or Claudius." Now, Mark's literary analysis is keen and fascinating,
But suggesting that Section 1 is like Osric, then suggesting it might be like Ophelia is a pretty big change. It's fair to say that Ophelia is far more central to Hamlet's story than Osric. That aside, Mark's discussion of Section 1's relative importance triggers a fascinating discussion. Precisely how important to the 14th Amendment is Section 1? The answer is, as any law professor knows, it depends. It depends on what the Constitution says, what the Constitution is, and how constitutional text is supposed to be used. And what you see depends on where you stand. So part of the question is whether this book is about constitutional law, is it about constitutional interpretation, is it about constitutional politics, is it about constitutional meaning, or some combination? And I think the answer to that question is, of course, yes. So how do we get into the material? I had a good, tight 15, maybe half an hour to do. But given the first panel, much of that's sort of gone out the window because part of it's been discussed. So let me start with a story. And I swear the story connects with the book. So fall of 2018, sitting in a gym watching a boys' high school volleyball match. Son's out there, he's having a good time, that's grand. But it's where the game is that's fascinating and who's playing. My son plays for the Freeman Rebels. Douglas S. Freeman Rebels. Douglas Freeman won a couple of Pulitzers for biographies of Washington and Lee. So you can kind of get a sense of where he is on that. Newspaperman from Richmond. As amusing as the Freeman Rebels are, they are playing, wait for it, the Lee Davis Confederates. And you say, that's interesting. I wonder which Lee, I wonder which Davis. And if you had questions, a nice cameo of them in probably 3 or 4 feet on the wall of the gym, Robert E. Lee, Jefferson Davis. Next to, of course, a big American flag, because who's more patriotic than folks who would name their high school Lee Davis and have their mascot be the Confederates? That, in a nutshell, to me, kind of deals with Mark's book. The notion behind the 14th Amendment was to punish treason and reward loyalty. But 150 years later, the real question becomes who is viewed as being loyal and who is being viewed as being treasonous. Again, this was 2018, so we're not talking about 1964. All right, no fists up. We're just talking about the first Trump administration. So when we ask that question, or when we think about that question, we ask, what does the book say to us? What does it tell us? Well, in some ways, it tells us everything. Because one of the things that Mark has done is he's gone back and said, well, what did the folks who were in the 39th Congress say? What were they thinking? And in some respects, he gave us sort of the full picture of what they were thinking they were saying. But it does raise the question, is that too narrow a lens or is it plenty wide? Because we know that Mark knows all of what happened at that time. But what's interesting is he didn't put it all in this book. So let me give you a sense of how I kind of think about the Reconstruction amendments in general, how it relates to the 14th Amendment and what Mark did, and a couple of pieces of the puzzle that we may want to consider. If we think about the Reconstruction amendments as being the 13th, 14th, 15th Amendments, great. You can see why the 14th Amendment, or why people gravitate to Section 1. Right? Not just because of what some folks said on the first panel, but because if you look at the 13th Amendment and the 15th Amendment, the obvious place to focus for the 14th Amendment, if you think of them as one long stretch, is Section 1. Right? Now, you might say, well, Section 2 has some issues regarding voting. Well, yeah, but some folks will argue that the 15th Amendment arguably repealed 14th Amendment, Section 2, or at least overrode it. Now, because all we tend to do is add words at the end of the Constitution when we amend it, we're not exactly sure what effect it has. We don't redline it. But the notion of what the 15th Amendment does to the 14th Amendment Section 2 is kind of an interesting piece of the puzzle. Now I mentioned that in terms of thinking, well, okay, so the 15th Amendment and how it relates to the 14th Amendment, important. We might even think about how the 19th Amendment relates to the 14th Amendment, since now if we talk about women's suffrage, we tend to look at the 14th Amendment as opposed to the 19th Amendment as to figure out what the specifics are. But we can also ask what the 13th Amendment had to say about the 14th Amendment. Mark does talk about that a fair amount and notes the 13th Amendment, if used relatively liberally, could very well do a lot of what the 14th Amendment did. And indeed, a lot of folks in the 39th Congress thought that as well, which raises the real interesting question. Is it possible that some of the folks in the 39th Congress were simply tired of talking about black people? And I say that because it gets easy to get tired of talking about black people. It got easy in 64. Got easy in 65. It was easy in 54. It's easy right now. Arguably, part of what's going on with SFFA is courts just got tired of talking about black people. You can ask yourself that question in late 1865 and early 1866. Is it possible that some of the folks there said, we've done it. We've handled the black person question, and that's one of the reasons why the 14th Amendment is not going to be focused on that. Now, there's reason to believe that it wasn't just exhaustion that structured the 14th Amendment. Indeed, Mark makes a good argument that it wasn't just exhaustion, it was that folks actually were thinking about former slaves, et cetera. And they explicitly said, we don't care nearly as much as we do about making sure that white loyalists are taken care of. Right? That's cool. It's a fascinating question in terms of what do we do with that? Because I'm going to take Mark as being right on that. But what do we do with that? That is to say, what do we do today with what we remember about then? Because as the book notes, after the colon, the forgotten goals of constitutional reform after the Civil War. What do we do with that? Now, I don't think that Mark is simply wagging a finger at us and saying, remember. I think he's doing a little bit more than that. We'll find out about 245. I think he's doing a little bit more than that. I think he's saying that not only is this about history, he clearly also says it's about politics, but it's not just about historical politics. It's still, in some ways, about politics today. And that's where things can get a little interesting and a little messy. Because part of the question that I think we need to ask or answer is, who gets to determine the meaning of the 14th Amendment? And this is actually a question that we can ask about, perfect. This is actually something we can ask about 1866 as well as asking about now. That is to say, when we think about what the 14th Amendment means, should we look at what the 39th Congress had to say about it? You may say, well, of course you do. And I may well say, well, of course we shouldn't. Why? Because what the 39th Congress wrote down is what they wrote down. What they agreed to is what they agreed to. The question then becomes, what do the ratifiers have to say about it? What did the ratifiers think was going on in the 14th Amendment? And then after that, who else gets into the game? So we could well say that the meaning of the 14th Amendment was decided by the framers who won. We could say it was determined by all framers, including the outliers. And Mark does a good job of talking about who is an outlier and who is not an outlier on various topics. We could well say that the ratifiers can also talk about what the 14th Amendment means, which could include all the outliers in terms of ratifiers. We could say, well, how about everybody who at the time was thinking about the issue? Here, for example, if we thought about Frederick Douglass and we ask, hey, Frederick, what do you think the 14th Amendment means? My guess is he's going to have an outlier vision on that, the same way he's probably had an outlier vision on the 13th Amendment. In fact, he might well have said, well, look, if we were serious about the 13th Amendment, we wouldn't have to worry about the 14th Amendment. And we wouldn't have to worry about the 15th Amendment either. Right? So who gets to determine that even at the time, and then ask, what do we today do with the concept that sections 2, 3, and 4 may have been the real core of the 14th Amendment? Do we say, you're right, it was the core and we need to rethink that and we probably should de-emphasize section 1? Or do we say, we're not going to de-emphasize section 1. We can't de-emphasize section 1 because that's the only part that still really, really, really matters. We thought section 3 didn't matter until January 6th, even though arguably there are times when section 3 could have mattered before then. But in that vein, here's one of the things we want to contemplate in terms of how do we determine what it means for today. I think part of what we have to worry about or what we have to be concerned about, or the reason why we get to where we get to, is a comment that was made in the prior panel. We're bound to remember what we like most about the stuff we did in the past. And once the world changed, once the loyalty question got muddy, once people who fought against the union could argue that they actually were for a grander union, or at least were for some of the principles that underlie the Declaration, et cetera. And once some people start to actually listen to them, the loyalty question moves away. And if the loyalty question moves away, arguably section 3 moves away. If we all agree that you're not repaying Confederate debt, section 4 arguably fades away. And with the 15th Amendment, arguably section 2 fades away. What do we like most about the 14th Amendment? It may be that we like the rights part the most because that's what makes us feel good about ourselves. And ultimately, we want to feel good about ourselves, our country, and the Constitution that we live under, and that most of us take an oath to. It may well be the case also that if you're doing politics, as Mark notes, and you're doing constitutional politics, it may well be that as soon as the politics change, you're going to have to move on from the language you passed. And you're going to have to go back to principles, and arguably in terms of long-standing principles that are not time limited, section 1 may be the part that is the least time limited or circumstance limited. So it may well be that if we look at the 14th Amendment as constitutional politics, as I think we should, then we're more than most likely to ignore or forget what it meant. What does it mean to remember? I'll stop there, in part because I'm out of time, and we'll go for it.
When I got the invitation from Penny to come here, I accepted immediately, not because at my age I any longer have a great desire to come to New York at all times for any reason, but because Mark and Jack Balkan are two very special people. I'm an only child, and they are two of the 3 people I would define as virtual brothers. Both have been absolutely central to my work, and so I'm absolutely thrilled to have this opportunity to discuss what I think is, without a doubt, the most important book that has ever been written about the 14th Amendment, especially if one combines that with what I know to be the forthcoming works in this project. Now, why is that? There's a paradox in the very title, especially at the top of the paperback, the forgotten 14th Amendment. From one perspective, that's ridiculous. If you ask most people, what do you know about the Constitution? They know astonishingly little about the Constitution, but they're likely to know about the 14th Amendment and probably the First Amendment. If you want to write about a forgotten amendment, there in fact is a book from the 1950s, The Forgotten Ninth Amendment, which was certainly true at the time. You could certainly write a book about the forgotten Third Amendment. But there is something paradoxical about the forgotten 14th Amendment, except that, of course, what is forgotten is what I think Mark conclusively shows is the most important parts of the 14th Amendment from the perspective of those drafting the amendment, that is sections 2, 3, and 4, and that those indeed have completely been forgotten. And that's where Mark's work and Jack's work on historical memory, which I adverted to in my question in the earlier panel, come together. Now, I want to put this in the context of another very important book that was mentioned during the first session, Eric Foner's book, The Second Founding. Eric is, I think, universally regarded correctly as the leading historian of Reconstruction, not only in our generation, but for all generations that have yet been here. My own view is that the title of his book, The Second Founding, is completely misleading in a number of ways. One can explain it because no doubt it helps sales. But if you read the book rather than the title, you realize that it wasn't a second founding. It was perhaps refounding 1.2, but it's not the replacement of the Constitution. Frederick Douglass has been adverted to. One of the things that is forgotten by and large in the Douglass oeuvre is an 1867 speech he gave on what Reconstruction should look like. And not surprisingly, it's all about structures. It's not about the addition of rights, which of course he would have supported. But for example, and he's a man of his time. And when he thinks of a president, he's thinking of Andrew Johnson. Therefore, no veto power. Therefore, no pardoning power. He also has some doubts about other aspects of the structure. So the fact is, the Reconstruction we got is not remotely close to the Reconstruction that Frederick Douglass would have suggested. And then one can ask, well, why is that the case? The most obvious answer, which is an important part of Mark's book, is that every single person who was actually a legal decision maker, forget all the people sending in petitions, et cetera, they're interesting. They're a part of the story. They ought to be part of the overall story, but they have no legal authority. People with legal authority were all white males, and their vision of what a Reconstruction might be was limited by that. If Frederick Douglass had been a senator, even a single senator or a single representative, he would have had the ability to speak on the floor. He would have had the ability to trade votes, et cetera, but he didn't, nor did anybody else. And so one has to take that into account. So why is Mark's book so important? It's not merely, it says, look, there are these other sections you ought to be familiar with. But what Mark does is to restore politics to the history of the Constitution. Partisanship. You might even want to call it revenge. You might call it a magnificent vision of transformation. I don't really care, because what we're talking about is a deeply, thoroughly to the ground political process. Now, let me go back to the notion of the founding and historical memory. I happen to be co-teaching a seminar with Larry Lessig this semester on what an Article 5 Constitutional Convention might look like. I'm also teaching a separate reading course on reforming the U.S. Constitution, because I do believe radical reform is necessary, and I'm one of the handful of people who very much wants a new Constitutional Convention. What I discover, I've already known this, not a new discovery, most people don't. And why don't they? It is because they fear a runaway convention. It is because they fear partisanship. And then you say, well, what about the 1787 Constitution? That's, from one perspective, that's part of the problem, because it clearly was a runaway convention. But there's a paradox. If you support the 1787 Constitution as a necessary replacement of a thoroughly defective, indeed, Alexander Hamilton called the system established an imbecilic system, then what's wrong with a runaway? So that's one issue. But what's also interesting is that all of these very, very smart students at the Harvard Law School, and many, many other people besides, are afraid of partisanship, are afraid of polarization. How can we possibly think of having a convention or talking about constitutional transformation when we're polarized, and when the ugly reality of politics and partisanship might exhibit itself. This, as a political scientist, this strikes me as kind of crazy. And it does seem to me that one of the things that has to be remembered is that the 1787 Constitution was not a gathering. Here's where the memory kind of conflicts, because the standard story of the 1787 Constitution, unless you're Michael Klarman, who writes a brilliant book called The Founders' Coup, but the standard narrative is that you had all of these selfless people, none of whom had a politics, who were coming together to engage in a Rawlsian debate about how best to construct a country in the common good. You know, somebody mentioned Charles Beard. No, you want selflessness and rising above politics, because there is something deeply within American political thought that wants all of us to rise above politics, above the ugliness of realizing that you don't achieve your goals, especially if they're really admirable, without engaging in politics and sometimes even constitutional hardball, or sometimes even bribery, if it's necessary to the end. So we have this image of a proper founding being apolitical and ideally one within limits. So I just read for our seminar, I had not read these things before, a couple of articles making heroic, wildly implausible efforts to prove that the 1787 Constitution was not a runaway, but that they really were concerned to act within their legal authority. And you ask, why would people do this? And it is because we really want to have an image of foundings that will be reassuring. And Mark doesn't reassure us on that score, because he properly says that it's politics all the way down. And I think this does generate difficulties for us that we saw in some of the Q&A, the previous column, that the previous discussion, that, you know, how do we engage in evaluation? Is constitutional hardball, bribery, et cetera, okay if it's our team that's doing it, and not okay if it's the other team? And one answer has to be yes. That if you really and truly do believe that certain goals are transcendently important, we're not talking simply about a couple of points on the next tax bill, but we're talking about transformation or preservation, then you do what is necessary. We can have significant debates about whether you adopt Malcolm X's view from Frantz Fanon, by any means necessary. My friend Randy Kennedy has just written a very interesting essay attacking the kind of easy reference to by any means necessary. But there are times when by any means necessary is correct. One of the things I will confess that I find extraordinarily frustrating about the response to the indefensible assassination of Charlie Kirk is the moral that violence never solves anything, violence should be forbidden, et cetera, absolutely forbidden. Well, that does seem to me a judgment call. One cannot possibly understand American history without paying due attention to the role of violence, beginning with the secession from the British Empire, going on to 700,000 people dying between 1861 and 1865. There are actually good reasons to be concerned about violence. I don't disrespect pacifists, but you can't understand American history from a pacifist perspective, and nor can you understand violence, including, for that matter, assassination. But at a public level, one cannot have a nuanced discussion of the uses of the means of violence. And what I kind of regret about the notion of the second founding and the way it forms our consciousness is that we don't have a serious discussion of what we mean by a founding or a refounding and what it takes to found and refound. It takes a high degree of partisanship and a willingness to be quite ruthless with regard to those who have a different vision. And it may even take, on occasion, a willingness to use the means of violence. And Mark's book refers to all of this. And it's a history that we need to be more familiar with. And so I think so much of the 14th Amendment, the so-called Reconstruction amendments, is forgotten because we have no real consensus on what we mean by Reconstruction, whether it is rebuilding an old house that served us quite well, except for this one glitch of slavery, or whether we need to tear down the old house and build a house suitable for the country we'd actually like to live in.
Hi, I come to this symposium with full disclosure, not as a historian, but as someone who has litigated civil rights cases and who teaches and writes in the area of civil rights, gender, and the law. And before I became a scholar, I spent a lot of time in Charleston, South Carolina. I represented Shannon Faulkner in her lawsuit against the all-males policy of the Citadel, which was the military college of South Carolina, and which I soon discovered. I came from New York. I was practicing law here in Manhattan, transplanted temporarily in Charleston. And it became clear to me that memories of the Civil War, of slavery, of Reconstruction were continually being contested in the present time. The case was litigated in the same courtroom where Briggs v. Elliott was decided. One of the mottos of the Citadel, one of the points of pride, was that Citadel cadets fired the opening shots of the Civil War. So I began to, as a Northerner, appreciate more the legacy of Reconstruction, of the Civil War, and how it shapes perceptions of race and racial justice today. So reading this book, I greatly enjoyed Mark's insights about the 14th Amendment, because as the book does, it challenges my understanding of the 14th Amendment as solely about the guarantee of rights in Section 1. Mark writes that Republicans believed the constitutional reforms were needed to prevent rebels from using their political power to achieve what their armed rebellion had failed to do. Unless political power remained in the hands of loyal Republicans, the rights in Section 1 would be parchment guarantees. Political reforms, he writes, were what was needed rather than the creation of new rights. Reading his account made me think more carefully and closely about the Supreme Court's recent decision in Students for Fair Admissions versus Harvard, because the contrast in the use of history between that opinion, Justice Roberts' majority opinion, and what Mark does in his book is startling. In that opinion, Justice Roberts writes that the 14th Amendment prohibits the use of race-conscious admissions in education. His opinion, as many have written, is profoundly ahistorical, announcing a principle of colorblindness that it justifies through the erasure of slavery, of the Civil War, and of the battle over Reconstruction in the post-conflict era. In the short time I have, I would like to discuss how Mark's book offers a response to that and how it allows us to help reconstruct the memory that that opinion seeks to erase. So first, I'll talk about the opinion, and then I'll suggest some of the insights that I found from Mark's book and talk about the importance of constitutional memory. So as Jack Balkin has written, lawyers and judges continually invoke and construct memory, and judicial decisions both rely on constitutional memory and produce constitutional memory. And as a number of scholars have written, the Supreme Court has narrowly interpreted the Reconstruction amendments, including the Equal Protection Clause of the 14th Amendment. And in many of these opinions, the court ignores and erases the nation's history of slavery, the Civil War, and the battle for Reconstruction. The erasure of our nation's racist past and present racial inequities are instrumental, I think, to the court's rationale and its embrace of formal equality and colorblindness. So if you read Justice Roberts' majority opinion, he begins his analysis in 1868, the time of the adoption of the 14th Amendment. He devotes approximately one paragraph to a discussion of its adoption, and nowhere in the opinion does he address the institution of slavery or the grave injustices it spawned, nor does he discuss the armed insurrection by Southern states determined to preserve that institution or white supremacy. It ignores the start and the end of the Civil War, as well as the post-conflict battle over Reconstruction. There's no mention of the political violence against Black and white Unionists in the former Confederate states, nor the ways in which those states sought to preserve a de facto slave system. In discussing the adoption, Justice Roberts picks three quotes from the debate. He proceeds to discuss state-sponsored segregation that followed the Black codes, Plessy v. Ferguson, and then moves into Brown v. Board. And in his discussion in Brown, he interestingly excludes references to race that the court wrote about in that opinion. He wrote, the purpose of the court wrote, the mere act of separating children because of their race, we explained, itself generated a feeling of inferiority. But he omits the next paragraph from Brown, where the opinion quotes the Kansas District Court. And I use the exact language from the court because I think it's important to its meaning. Quote, segregation of white and colored children in public schools has a detrimental effect upon the colored children. The impact is greater when it has the sanction of law, for the policy of separating the races is usually interpreted as denoting the inferiority of the Negro group. Close quote. That part, the portion of Brown that I think most think is central to its decision, is erased in Roberts' opinion. He omits the post-Brown jurisprudence of the court in Swan, a number of cases where the court accepts race-conscious remedies to achieve desegregation, and instead concludes eliminating racial discrimination means eliminating all of it. Jack Balkin reminds us whatever is erased from memory loses its power to shape meaning. And so by erasing the memory of slavery and the war that was fought to preserve it, the Roberts Court constructs a principle of formal equality that denies the violence of the past and the legacy of racial equality. Justice Sotomayor, of course, seeks to counter that ahistorical narrative by her dissent, in which she recounts and recenters slavery, white supremacy, and our understanding of the 14th Amendment. Turning to Mark's book, although his book downplays Section 1, it seems to me that his deep analysis of the congressional deliberations over political reforms in Sections 2, 3, and 4 helps counter Robert's cramped vision. And interestingly to me, he begins by noting the 14th Amendment must be read in conjunction with Reconstruction. So he broadens the narrative to take into account what Congress thought about Reconstruction and the importance of that process post-conflict in its understanding of the 14th Amendment. He writes, Black codes played an important part in Republican thinking about Reconstruction and the problems of rebel rule, and argues it was not their primary target. But nonetheless, he presents ample evidence in this book that Congress was concerned that rebels in former Confederate states were seeking to preserve white supremacy. And they did this in a number of ways that denied citizenship to formerly enslaved persons and continued to celebrate and promote white supremacy and racial subordination. So we look to chapter 2, where he begins by describing how the former slaveholders embraced politics as war by another means. And this section here, I think, is replete with ample evidence of the concern the congressional Republicans had for what was going on in those states and the need for not just paper guarantees in Section 1, but for political means to enforce those guarantees. The quote from Representative Lone from Missouri was striking to me. Quote, "They remain determined to destroy this government and erect another on its ruins, the chief cornerstone of which is to be African slavery." Professor Graeber provides an incredibly detailed account of the ways in which home rule, he argues, was tied to racial subordination. And one piece of evidence presented to the Congress was a journalist report that 99 out of 100 men, women, and children in those former Confederate states believed slavery was and is right. Black codes created new laws, both civil and criminal, to re-enslave Black freedmen. Slaveholding elites denied freedmen access to land and economic opportunity, perpetuating the material conditions of slavery. He notes how Congress was aware white planters, for example, refused to pay wages to their former slaves, and that there were no legal consequences. Courts participated in the continued racial subordination of Blacks. The suppression of civil rights was enforced, of course, through private violence, which was countenanced, he notes, through indifference through such violence by local officials. And so thus, Chapter 2 details the continued political, social, and economic rule by the white planter class, who continued to wield political power at the local, state, and federal levels. Mark's book, I think, demonstrates that Congress believed political empowerment is necessary to guarantee the civil rights in Section 1. And his insistence on construing that amendment with regard to Reconstruction, I think, helps us reconstruct the memory of the Equal Protection Clause and to restore context to the court's understanding of what equality means. The lens can be broadened, of course, beyond just the adoption of the 14th Amendment. As other scholars have noted here and elsewhere, the 14th Amendment needs to be read even more broadly in conjunction with the 13th and the 15th Amendments, in conjunction with the Civil Rights Act of 1866 and 1875, the Force Acts of 1871, and acts like the Freedmen's Bureau. And read more broadly, I guess I urge thinking of sections 2, 3, and 4 not as separate and apart, but in conjunction with sections 1 and section 5. And I look forward to seeing the next 2 volumes and looking at a closer read, for example, of section 5 and what that would mean for giving greater effect to the rights in section 1. Thank you.
Thank you so much. I wanted to start by giving the panelists an opportunity to respond to each other, and then we'll go to questions from the audience. Any initial?
Yeah. So I want to throw 2 gauntlets down. The first is with regard to the patent inadequacies of Roberts' opinion, the Harvard case. Is it any worse than Chief Justice Warren's opinion in Brown, which I regard as unteachable? That is, there is no education in Brown about why there are segregated schools in 17 states, including Kansas. Warren knew what he was doing. He wanted to write a non-confrontational opinion, and therefore there was no useful information provided about the case, which is one of, except that there was this phenomenon in 17 states. And then there's the further problem or paradox that why do we take seriously any citation by the Supreme Court of controversial matters of social psychology, or for that matter of American history? God knows American legal education does not focus on preparing its students to be competent in either of these areas. But we do teach them to read cases which include casual asides. Now, I presume all of us agree with footnote 11, but we also are very well aware that that elicited a great deal of controversy, and not only from Southern segregationists, but from social psychologists who criticized the Kenneth Clark experiments, et cetera. But the point here is just, what standards we use to evaluate an opinion. And incidentally, just as a snarky aside, wasn't it say that John Roberts got a Summa degree from Harvard where he concentrated in history? And then he writes, an opinion like the one he did. But the other gauntlet to throw down has to do with the 13th Amendment. Jack and I wrote an article years ago on the fact that the 13th Amendment, you could write a book on the forgotten 13th Amendment, because we argued, I think correctly, that if one took the 13th Amendment truly seriously, it would require all sorts of radical transformations. But that would also mean wrestling with what we mean by slavery. And the fact is, there's no consensus on what slavery means. The most interesting thing about 19th century thought, or 18th century thought, is that our founders thought that the Brits were out to enslave us. That's the language they used, because they had a theory, Republican theory of slavery, that it's illegitimate domination. And so you had languages of the slavery visited on women, or wage slavery. Chattel slavery was simply one form, the worst form of a larger institution, but there was this larger institution. That's disappeared. That's been totally forgotten. And so we tell our students and ourselves that slavery was eliminated by the 13th Amendment, which is true if you mean by slavery chattel slavery. That, Jim Crow is not chattel slavery. One response is big deal. Another response is this is a big deal. But what is absent from the discourse is a theory of slavery. And one last paradox of the 13th Amendment is that just as Section 2 of the 14th Amendment is the acknowledgement that this is a country run by men, because it's perfectly all right to deny women the right to vote. That's not going to lose you representation. The 13th Amendment is the one time that slavery is actually used in the Constitution. And what it says is that slavery is legitimate as a punishment for crime. Now, what does that mean? I have no idea. But we do know that the 13th Amendment almost mindlessly repeated the Northwest Ordinance, which also had this language. And so it's just there. And one other thing Eric Foner teaches us, if you read the book rather than the title, is that all three of the amendments are the product of necessary compromise, because whatever you think of the people in control of Congress, they did not engage in running away. They recognized they had to make compromises with other politicians. And so the texts of the 13th, 14th, and 15th Amendment are much more moderate or incoherent than Charles Sumner would have written. But Charles Sumner wasn't in charge any more than Frederick Douglass was in charge.
Yeah, it is nothing in those comments, right? No. If you throw down gauntlet after gauntlet after gauntlet, it's like 2 gauntlets, and then 10 gauntlets later, here we go. So I think you raise a bunch of real fascinating issues, and I'll let them sit and just mention a couple of pieces of the puzzle that I think are kind of messy, but that jump off of what you had to say. One is that I suspect that we have different visions of who matters for what amendments mean. And this is what I mean. I never talk about the Constitution of 1787 because I don't believe that there was a Constitution of 1787. That is, the Constitution doesn't exist until it's ratified, and it wasn't ratified in 1787. So the Constitution as a thing, for me, doesn't exist until it gets ratified. And what goes into what gets ratified are all the thoughts of the folks who are ratifiers. That's the reason why I mentioned Frederick Douglass and other folks as well. Not to say that he ratified the 17, but point being, you look outside of the people who framed the thing, and you say, what did I think I was agreeing to at the time? Which is one of the reasons why I think the anti-federalists are perfectly reasonable people to look at, not just because ultimately they arguably won, but because part of their arguments can well be, I'm against this thing because this is what it means. Even if what they say it means may be a little different than what some other people say it means, which is one of the reasons why when we look at the Federalist Papers, it seems a little odd because we know why they were written. They were written in order to get people to support the thing. So of course they're going to take a position that people will ostensibly like. So that's sort of one piece of the puzzle. It's the reason why I say, well, broadly speaking, I need to know how people would interpret it. I think what you said about the 13th Amendment, of course, is fascinating. I think it's fair to say that 30 years or so ago, fewer people would have said slavery is allowed as a punishment for crime. We might have done backflips to say, well, given where the comma is, involuntary servitude is allowed as a punishment for crimes, but slavery is not allowed, which raises a particularly kind of an interesting question, because if your notion is that slavery is allowed as punishment for a crime, then that means that slavery wasn't abolished. And if slavery wasn't abolished, then a whole bunch of other things go by the by, and we got a real problem. And now the 14th Amendment takes on even additional import, arguably. And frankly, the first section really takes on additional import if slavery as punishment for a crime is possible. So those interpretive questions are real messy. I think at the end of the day, part of the question is, are we doing politics here or are we doing law? Or are we doing both? And I think we're probably doing both, but who thinks what is politics and who thinks what is law is what differentiates among a lot of folks who are out there. And that in part gets back to what Val's talking about in terms of, you're talking about law stuff, And I think Roberts is claiming he's talking about law stuff, but he's really talking about politics. And that's part of the problem. And that's part of what's so annoying when you kind of get the feeling that his notion is, well, I'm just doing law. You're doing politics. It's like, no, dude, you're doing politics. We're all doing politics. We just try to dress it up in some measure of law. But I'll stop there because I bet Val's got something to say.
One very quick point. Frederick Douglass is endlessly fascinating. So the question is, are you going to cite the Garrisonian Douglass, who said the Constitution was covenant with death and agreement with hell? Do you cite the Douglass of 1854, who says that it's legitimate to kill U.S. Marshals for being complicit in the kidnapping of alleged fugitive slaves? Or do you cite the Douglass that gave a speech in Glasgow, that is in fact in our case book, that presents the notion that the one true Constitution is anti-slavery? So it's take your pick.
Yep. Yep.
No, I completely agree that the Brown decision is also deeply ahistorical, and you can see why the court did it that way, to not offend people. It was a dramatic shift in the structure of our country, but it also ignores the roots of racial inequality in education, and I think that's an excellent point to remind us how history can be used selectively or ignored to shape our arguments about principles. And a decontextual, acontextual, ahistorical analysis of racial inequality, I think, just allows one to create a minimalist commitment that is meaningless.
Okay, we can turn it to questions, and we'll start with Penny. I think you've been waiting for a while.
Thank you. My question actually was triggered this morning, but also continuing the conversation last night with Ruti's book on transitional justice. And I don't know, this morning, I think maybe Jack raised the question about what constitutions can do. So when I think about the sort of, last night we spoke about Reconstruction as a form of, transitional justice, and we know that we will confront again a period of transitional justice, or some transition. Let's just say transition. So a lot of what the Constitution says, the text, and what the meaning that we try and put into it, I'm interested not so much in whether it's rights we're talking about or structure, but I'm interested in sort of culture, the sort of a culture of a constitution and the culture of those who are involved from the top but also the bottom. You raised that question last night, David, to Ruti. And I don't know if this is a Pollyannish question, but if the Constitution is going to be successful, and I think about it as transformative, because I struggle with this in South Africa. We have a great constitution, a highly admired constitution. We have an incredibly illiberal culture. So the dissonance between what the elites see as what the constitutional text should do is great. And I think that if we think about constitutional literacy and constitutional culture in the United States today, if we are going to have a transition of some kind, how does the Constitution, what can a constitution do if it's not going to transform the ethos of at least a shared sense of what values are? What does white supremacy mean? Those sorts of questions. And so I know in South Africa there's been a move among young scholars to just reject the Constitution, the constitutional framework, and so on. But I do think it's a very difficult question, because elites, we like the Constitution, we can talk about it endlessly. But the huge majority, I would say today in the United States, the huge majority of people are not, on TikTok or, concerned about what the Kardashians are saying. Or maybe I'm making an elitist statement, but I do sort of wonder about how how the Constitution is transformative in terms of a different kind of political and legal culture.
I think it's a terrific question. Let me offer a very tentative suggestion. that the 1787 Constitution was not designed to be transformative. It was designed to create a structure of governance that was not imbecilic, that the Federalist Papers, especially the first ones, are all about protecting the United States from a whole bunch of countries and Native American nations that didn't wish this new country well. So the two most important things in the Constitution were the power to tax and a standing army. And they're institutionally transformative, but they're the 1787 Constitution was not self-consciously culturally transformative in a way that, let us say, the South African Constitution was designed to be, or the Indian Constitution. And the Indian Constitution is very interesting in this respect. It was clearly designed by secularists who wanted to destroy the hold that Hinduism had on Indian culture. It failed. And then, so the question is, what accounts for that? But one difference, arguably, between Reconstruction and 1787 is that Reconstruction was hoped by people like Sumner and Stevens, and certainly Frederick Douglass, to be much more fundamentally transformative exactly in the ways you're describing. And how do you do that? I think that is just, the right question to ask. And I have no idea, frankly, whom we look to for authoritative answers.
So I'll just add a couple of pieces from today and from yesterday. I think the question is key. I suspect that part of our problem is the concept of democracy. That is a wooden vision of democracy as being about majoritarianism. And if I win, if I get 51%, good enough. And as a consequence, we don't have to care about those people who are not going to make up part of the coalition, which arguably is part of what Mark's book suggests is if you need black votes, we'll protect them. If you don't need them, who cares? And that gets us to today in a couple of ways that also track part of what Val was saying in terms of not thinking about black folks. So I'll just boil it down because I'm looking at my wife up there. Hi, honey. So when we watch Jeopardy together, typically there are a couple questions that are about black folks. And typically the contestants look at each other and have no idea what's going on. And when that happens, my wife turns to me or I turn to her and I just go, black people. Because in this country, you can be deemed highly educated and know nothing about minority people or virtually nothing about them because they don't matter in a lot of ways, which is one of the reasons why we get to today, which of course is about the problems with Bad Bunny at the Super Bowl. As people ask, why don't you get an American? Like, well, he's Puerto Rican. So he's been an American citizen for his entire life. He just happens to speak Spanish. But it's okay for us to come out and make these comments without even thinking twice about what it means, let alone our Native American brothers and sisters or our Hawaiian brothers. So I think that's part of what's going on. And I think that the notion of democracy and the need to have control, but viewing control not being control and caring about 100% of the people, but just caring about 51% may well be a part of the problem. And I don't know if there's a way out of that.
One addendum, I think Hank's absolutely right, but one addendum to this suggestion, we don't really need to talk about, or we don't talk very often about 1787 or 1789 as a transition. Because one of the miracles, and there is a literature on this, why did the losers give up so quickly? Anti-Federalists denounced the Constitution. It passed 30 to 27 in New York. But They were all good sports. Why? And one reason is because they quickly realized it wasn't transformative. Whereas the great story of Reconstruction is that the losers didn't give up. They weren't good sports. They were insurgents, etc. And that is because they recognized that it was intended, at least by people like the late Thaddeus Stevens, to be transformative, and they didn't want to be transformed.
And I mean, just to Penny's question about the role of elites, when I think about the language of Section 1, for example, and the aspirations that are expressed there, the potential of the words to lead to transformation, I then think, who adopted it, right? White men, largely, by and large, at a time when the voices of women, the voices of most Blacks, were not heard, didn't participate in any sort of making of the meaning of what those guarantees meant. So when you have the exclusion of a huge number, right, more than 50% likely of the population in those deliberations and in that adoption, it does raise the question of how there's no consensus of what it means or where the country is going. Maybe there's no second founding. There's no moment where we say these are our new aspirations.
So Sandy, how do you envisage the Constitutional Convention? Who attends, who gives input, and so on?
The only plausible answer right now is that that would take much too long to give a genuine answer, but I actually would select delegates at random. It would be no elections, no appointments, for a variety of reasons I could explain at great length and persuade very few people, I've discovered. And everything would be on the table. So I don't fear a runaway for a variety of reasons, but that gets obviously very, very complicated. And I will simply state that I can't even carry my own family, let alone my friends and professional colleagues, with regard to the kind of constitutional convention that I in fact support.
Would secession be on the table?
Of course.
Sandy, didn't the Irish do that with respect to the abortion decision?
Yeah. I mean, there are a lot of countries that have, experimented with sortition. One last point, so before I hand this off. In the old days, involuntary servitude was a form of slavery. So even if one wants to say, read the commas very carefully, you can say, well, you can't have chattel slavery. That's like bill of attainder. Your children will be slaves. No, that's out. On the other hand, involuntary servitude is perfectly all right. And involuntary servitude of the kind that is being imposed on a lot of federal employees this very day, go to work even though we're not going to pay you, would have been defined by the founding fathers as slavery. But we've lost that language because everybody thinks that slavery is chattel slavery.
Yes.
Minutes.
Just a follow-up to your question. I wanted to write, maybe the fourth volume is called The Really Forgotten 14th Amendment, which includes all the proposals that didn't get in, but were debated seriously. The New York Post has an editorial in early December 1865 saying, here are the 10 points. And point 9 or 10, I believe, is universal education. Now, it's interesting. Some of the points are specific constitutional amendment. Some are not. This is one that is unspecified how we do it. And almost every African-American convention of the time, it's voting rights and we need education. By the way, it's not section 1. It's voting rights and we need education. And what happens in early Reconstruction, in Southern state governments, where African Americans are either a majority or a substantial plurality of the legislature, we get education, which is designed to be the transformative agent, because it's a Northern theory, among other things. Why did these people go along with these Southern elites? Because they were poorly educated. Ignatius Donnelly says, if we just bring the Northern schools south, we will have transformative results. So that's, I think, where it's located. And now, and this is just a hunch, but it's not simply a hunch. It's a hunch based on things that it's not, I don't have the research yet to fully back it up. What happens when Reconstruction legislations begin spending a lot of money on education? Some Northern radicals say exactly what we hope. A lot of Northern moderates say, oh my God, these profligate legislatures, we didn't think this was gonna happen. We thought the Civil Rights Act of 1866, yeah, no discrimination, but not that they'd be spending money right and left. And the result is a weakness in Northern support, which is absolutely crucial for the structure of the 14th Amendment. But I think that may be how the story takes place. Once again, it's a concept. The idea was that if we reconstructed Southern politics, we didn't need an education amendment. Yeah, we already educate in the North, they will educate in the South.
Well, you certainly trigger an issue in terms of thinking about HBCUs, many of which sprung up right after the Civil War ended. So Virginia Union, where my father went, Howard University, where my mother went, lots of places that sprung up. The concept of education, of course, was an important one, and that's what folks wanted. And of course, that was part of what was kept away from slaves at the time. Just have to throw out one additional piece of the puzzle in terms of how we think about race. Black people have certainly used the term Black people, et cetera. What that meant in the 1800s was also contested territory, because there were plenty of people who were of mixed race, and everybody then knew it. It wasn't a surprise. So how do you think of the concept of Black, white, biracial, et cetera, in societies where everybody knew that there were admixtures of race is another fascinating question, and makes us ask, what exactly, again, were they doing with respect to the 14th Amendment? Obviously, Frederick Douglass was mixed race, although at the time we would all say he was Black. So lots of things going on here, but Mark's book opens up the window to all of these things. And anyone who hasn't actually read it, I think there are copies here that Penny's going to make Mark sign. So just one of those things.
And you can do that. You can pick up one on the way to lunch. So we will leave it there to have an hour for lunch. And if there are questions that were not possible to ask, maybe the next panel can gather those questions. Lunch is on this floor, just down the hallway.
Right, left, and left.
And thank you to the panelists and all the questions and all of you. Thank you.